Jane, a commissioned notary public in New York, is approached by her neighbor who wants to transfer real property to their child. The neighbor asks Jane to draft the deed and a related will. Jane agrees and charges a fee for preparing these documents. Additionally, Jane promises to represent the neighbor in a small claims court proceeding, even though Jane is not an attorney. Jane also charges more than the statutory fee for notarizing a standard affidavit for the same neighbor. Finally, Jane never took or filed the required oath of office after receiving her notary commission. Which of the following statements are accurate under the laws provided? 1. Jane's preparation of a deed and a will for another person for a fee constitutes the unauthorized practice of law. 2. Jane's representation of another individual in court without being admitted as an attorney does not violate Judiciary Law Section 484. 3. Charging more than the statutory fee for administering an oath can subject Jane to treble damages in a civil action. 4. Acting as a notary without having taken and filed the required oath of office is a misdemeanor. To help us answer this question, let's have a look at the Judiciary Law, Section 484, found in the Notary Public License Law booklet entitled None But Attorneys to Practice in the State. And I'm not going to read from this paragraph, but it makes it clear that unless a notary public is also an attorney, the notary public cannot practice as an attorney. That would involve preparing legal documents such as wills or appearing in court for a person, and a notary public who does that is in breach of this section. Let's also have a look at Section 67 found in the Notary Public License Law booklet entitled Fees of Public Officers, and if we jump to Section 2, it states, an officer or other person to whom a fee or other compensation is allowed by law for any service shall not charge or receive a greater fee or reward for that service than is so allowed. As well, if we jump to Section 4, it states that an officer or other person who violates either of the provisions contained in the section is liable, in addition to the punishment prescribed by law for the criminal offense, to an action in behalf of the person aggrieved in which the plaintiff is entitled to treble damages. And finally, if we have a look at the Public Officers Law found in the Notary Public License Law booklet as well, it states, notary must not act before taking and filing oath of office. The Public Officers Law, Section 15, provides that a person who executes any of the functions of a public office without having taken and duly filed the required oath of office as prescribed by law is guilty of a misdemeanor. And the law makes it clear that a notary public is a public officer. So with all this in mind, let's once again have a look at the four statements to determine which one of these is accurate. Statement 1. Jane's preparation of a deed and a will for another person for a fee constitutes the unauthorized practice of law. This is correct, as we saw in the law before. Only a notary public who's also an attorney can practice law. Jane is not an attorney, and therefore statement 1 is accurate by stating that Jane preparing the will and deed was an unauthorized practice of law, and we can put a check mark next to it. Statement 2, Jane's representation of another individual in court without being admitted as an attorney does not violate Judiciary Law Section 484. This is not accurate. In fact, Jane was not allowed to represent another individual in court. This falls under the guise of practicing law. Therefore, by stating that it does not violate Judiciary Law Section 484, that is not accurate, and we could put an X next to number 2. Statement 3, charging more than the statutory fee for administering an oath can subject Jane to treble damages in a civil action. This is in alignment with what I read from in the law before, Section 67, and therefore Statement 3 is accurate, and we can put a check mark next to it. And finally, Statement 4, acting as a notary without having taken and filed the required oath of office is a misdemeanor. This is correct based on what I read from in the law before under the Public Officers Law, and therefore we can put a check mark next to number 4 as well. So with all this in mind, let's have a look at the four choices to determine the solution. Choice A states 1, 3, and 4 only. This is the correct solution based on how I described the four statements above. We've got check marks next to 1, 3, and 4, but not 2. But to be in the habit of looking at all four choices, let's have a look at choices B, C, and D. Choice B states 1 and 4 only. This is incorrect because 3 is also accurate, and therefore choice B is not the correct solution. Choice C states 2, 3, and 4 only. This is incorrect because 2 is not accurate, whereas 1, 3, and 4 is, and therefore choice C is not the correct solution. And finally, choice D states all of the above. This is incorrect because 2 is actually not accurate, therefore choice D is not our solution either, which indeed leaves choice A, 1, 3, and 4 only, as the correct solution.